But outside the courtroom, the advocacy of the bar as a professional group has lacked consistency, bringing into question its adherence to principle. Ladies and gentlemen, when in 2015, an Article 146 petition was received by the Chief Justice in relation to the former chairperson of the Commission on Human Rights and Administrative Justice, Madame Loretta Lamte, the bar failed to speak out about process. In the run-up to the 2016 elections, the then opposition New Patriotic Party engaged the Electoral Commission in court battles over the voter identification system. This gave rise to the Abu Ramadan line of cases. Immediately upon assuming office in 2017, an Article 146 petition was filed for the removal of the chairperson of the Electoral Commission, Mrs. Charlotte Osei, and her deputies from office. The bar saw no basis to speak out about compliance with due process. But in recent times, the bar found its voice when petitions based upon the same constitutionally defined procedures were brought in respect of the removal from office of the former Chief Justice, Mrs. Gertrude Araba-Tokono. Ladies and gentlemen, the honest question we have to ask ourselves is, what changed? The three petitions aforementioned touch and concern office holders of three constitutional bodies critical to the sustenance of our democracy. The independence of the three institutions has been guaranteed by the Constitution. The three occupants were all women of significant repute and members of our noble profession. The three committees established pursuant to Article 146 complied with the constitutional procedure to the letter. And yet, the bar found its voice only in relation to the third petition. Coincidentally, the voice of the bar amplified the voice of the opposition. The lawyer in politics must be a voice of reason, moderation, and constitutionalism. The bar must speak out not to please governments or opposition parties, but to defend the rule of law, the independence of the judiciary, and the rights of the ordinary citizen.